Good. Merry Christmas to everybody and Happy New Year. Happy and healthy New Year to everybody, and hope everybody will be healthy and prosperous in 2024. Not legal advice. Please like, subscribe, and share. Really, please share. Show it to other people. Perhaps they will get something of value out of it. It's always appreciated. Um, anyway, uh, don't take any of this as legal advice. That's why it's called not legal advice. Please check everything out yourself and feel comfortable with any decision you make. I would always consult experts before I made any significant decision. So I'm going to briefly go over a bunch of topics, including Alpine, South Korea, MMTLP, finger motion, shorten, distort, Tesla, etc. But of course, before we start that, I wanted to add a couple things, and we're going to do a little differently today. I'll give you a little bit of humor related to the season, and at the very end of the video, I'm going to do some regular jokes at the end. So we'll do it that way. So why would you not lend money to elves? Because they're always short. How did Scrooge win soccer games? The ghost of Christmas passed. And last but not least of our first round, what is green, covered in tinsel, and goes ribbit, ribbit? A mistletoe, of course. So I'm going to shotgun style. We're going to go through a bunch of topics. Alpine, which is GTII. Alpine obviously was the prime broker for the GTII matter. That matter is on appeal. There was a oral argument date set for February 8th of 2024. I will be following that. Obviously, that oral argument will be prior to the decision. Usually, if the oral argument's in February, decision's probably going to be by April. At the same time, which will be interesting, the Jerkesi matter that we talked about before, which involved the SEC going against a particular member and questions the judicial position of the SEC, may have been decided by the Supreme Court before the decision in Alpine, the appellate decision. So we'll have to see. But it'll be interesting, obviously, if Alpine loses, that makes their position even worse. If they win, it just delays the inevitable. I think they're going down the tubes anyway. But we shall see. I've already stated that I think they should lose this particular battle because of the injunction issue. But anyway, that's me. So we will keep on track, and that may impact GTII, obviously, because a lot of people think if Alpine goes south, that will impact GTII stock. I don't know that, but that's what a lot of people assert, so we shall see. Second, there was reported this week out of South Korea that I think there was 2 banks that were fined, and others may have been fined. I think they established what the amounts were. They might have been even in the millions of dollars, the low millions of dollars. And obviously, I don't think that has any impact. Okay, it has limited impact on dissuading these people from doing this nonsense because it's just a fraction, just a cost of doing business. So I had suggested last week, and I just kind of want to reiterate, if it were me and I wanted to stop this misconduct, obviously you could put people in jail and that would do it. So this isn't on, and but that's more difficult. The standard of proof in a criminal trial is different than in a civil trial. Usually in a civil trial, it's just a preponderance of the evidence, so just more than 50%. In a criminal trial, it's beyond a reasonable doubt, which is a much higher standard. So that's why a lot of times the regulators go after civil remedies as opposed to criminal remedies. So South Korea imposed some fines of a nature. If it was against me, it'd be significant, but it wasn't against me. So in terms of the monetary impact, it's I think very little. So what would I do? Well, what I would do is I'd set up a system where by the first violation would be in essence a warning. I'd give you a $500,000 fine. I would get a disgorgement, and I'll talk about what that means, of any monies you made, and we'd move on, and you'd be on probation. If you committed a second offense, there would be $1 million fine, a complete disgorgement of any profits, and a 30-day suspension of business. So you'll not be able to conduct business for 30 days. And third, if you do it a third time, so you've been warned, so it happened once, happened twice, now it's a third time. And by the way, if it happened to you once or twice, that means you just got caught once or twice. That means you probably engaged in the conduct much more than that. But if you get caught a third time, then my solution would be you are suspended for a minimum of 1 year, fined a minimum of $15 million, and you have to disgorge all your profits. What's disgorgement? That's a remedy whereby, so if you make money on a deal, you have to give it all back. And it doesn't require a jury trial or an Article 3 trial in federal court. That can be done by FINRA or the SEC. That's been determined that could be done. So I think the South Koreans should look to us, not to the regulators in the United States, and the penalties should be much harsher, because we want this stuff to stop. All right, MMTLP. Before I get into my arbitration, I know that Congressman Norman had a letter go out to FINRA and the SEC, signed by 71 representatives. I think it's bipartisan. That was sent out. As far as I know, that's great, by the way. As far as I know, no subpoena has been sent out, and we have a running clock. So I want a subpoena sent out. But I appreciate and am using Congressman Norman's letter. So we shall see if there's a response from it. We will see. So my arbitration's ongoing against MMTLP. So that was MMTLP. Now my arbitration is ongoing against MMTLP. I think my last statement to you was I was trying to get the arbiters disqualified because they ruled on various motions that I had filed, some for special discovery, and they had denied all the motions. So I asked, and I had objected to the panel beforehand anyway. So now after we've started, now I'm objecting to the panel for different reasons. And in essence, and it's pretty straightforward, but in essence, I've claimed either they're incompetent, they're biased and prejudiced, or there's some other reason for them not to be carrying out their oaths. Their oath is to not prejudge, not have bias, and to undertake a fair arbitration. So I'm claiming they did not do that. Not very nicely, by the way, because I don't think they have acted in an appropriate manner. So what are my concerns? So again, we have a U3 halt MMTLP. We have a U3 halt. A U3 halt was the reason why FINRA stopped, or allegedly stopped, the trading on December 9th. U3 halt requires extraordinary circumstances. To get discovery, so in a arbitration in FINRA, you get some discovery, but it's limited, so you can't take depositions. To get depositions and to get discovery outside of what's normally permitted, you have to show some kind of special circumstances. So I asserted that U3, by definition, found by FINRA, was such a special circumstance, and that we were entitled to various depositions of various people, including Sam Draddy and Patricia Casamates, who were involved with FINRA as or about December 3rd and 4th of 2022, when all this went down. They were involved when all the brokers were blue sheeted. And this all occurred before I obtained any of my MMTLP shares. So I think because they represent FINRA and they were involved and around, that I should have the right to investigate it, especially since it involves a U3 halt, which is extraordinary. It's happened very few times this century, etc. So I've asserted that. And on top of that, I've also asserted, how could these guys who never have dealt with a U3 halt known what they were deciding without a hearing and without showing any reasoning? So in essence, what they've done here is they made a bunch of rulings. There was no hearings. They heard, there was some papers that were filed, but no hearings. So no discussion of U3 halts, how it applies, what Congress is doing, etc. And they didn't give any reasoning for the decision. So when you don't have a hearing and there's no reasoning, it makes you suspicious of the actors. And so that's why I've asserted, that's why I've made the request to get rid of these guys. On top of that, I've made a record. So there's a record now in the arbitration, but beyond that, I'm making a record in the federal court, because if I'm not satisfied with the outcome of this proceeding, the remedy is to appeal in federal court. Usually there's not a lot you can appeal, generally. In this case, I think there is a lot to appeal, and I'm letting the federal court know it as we go on. The federal court required us to report, so I'm going to send a report. I'm going to include the pleadings I prepared challenging the panel. I will also include a copy of the letter, the Ralph Norman letter. So the federal court, who has jurisdiction for the final determination, even though they usually just follow the determination of the decision maker, will have these documents in their file. So to the extent I challenge the decision, if it goes against us, the court will have more before it and will also know that we were dissatisfied with the process throughout. That's the idea. And everything I'm saying within the paperwork is absolutely true. Why they didn't have a hearing, why they didn't state the reason, why they don't understand that the U3 halt exceptional circumstances is basically the reason why special discovery should be permitted, why someone who's paid by FINRA, who gets work from FINRA, should make a decision about whether FINRA personnel should be deposed seems to be a violation of conflict of interest rules. These are all various things that I've asserted. We will see what goes on. We'll see if they change their tune, but the federal court will be aware of this, and I obviously will keep you apprised when I have more information. For the short and distort, so apparently Lynn filed or suggested that there was shenanigans going on with finger motion. Now, of course, they didn't identify the people. I think they just referred to nefarious characters. They asserted, I guess, some vague assertion about their short position within a specific time frame. So they might have said, I'm making this part up, but they might have said, during 6 months, we didn't have a short position. Therefore, whatever. They didn't say what that means. They just asserted that they personally did not have a short position. Whether they were maintaining or assisting someone else to have a short position, they were getting some remuneration otherwise with regard to the stock, whether they had a short position before, what they did, how much money they made, etc. They've never stated that. But what's interesting is they sent out this report in an attempt to impact in my view, in an attempt to impact the value of finger motion stock without saying anything. Seems really harmful. And for anybody out there, when you see these reports that don't refer to people, that have this very vague, non-specific allegations, I think you should be suspicious of them and you should not take them at face value. Because I think most times, most of these reports seem to be bogus and designed only to lower the stock price, not to do anything else other than lower the stock price, because these people have short positions. So I am very skeptical of the shortened report by Lind. And I also indicated to Lind that if they wanted me to prepare an affidavit where they could attest under penalty of perjury to the accuracy of them never being a short holder, etc., 5 or 6 different things, I'd be happy to do it at no cost to them. Since I made that offer, surprisingly enough, I've not heard from Lind accepting my offer. So that makes me somewhat skeptical of these jokers. But, that's all I know at this point in time. Tesla. Elon Musk was speaking to Kathy Wood, who is a big proponent of disruptive technology stocks. And during that discussion, which I think was last week, Elon said that he thought that retail shareholders need to have a bigger position in the market. So I thought that was interesting, because he's also been at least discussed the issue of the nature of short sellers, of there being no necessity for it. We know Tesla stock has been shorted endlessly. So anyway, that statement was interesting. That's that. And I think that's all I'm going to go over for today. Those things. And as we leave, I'm going to do the backside of what I said I was going to do on the front side. I ordered a chicken and egg from Amazon we will see for the first time which comes first. I went to the doctor with a suspicious looking mole. The doctor told me that they look all the same and that I should have left it in the garden. And last but not least, why do seagulls fly over the sea? Because if they flew over the bay, they'd be called bagels. Anyway, everybody have a great holiday. Be well. Happy New Year. You'll hear from me again sooner or later, like it or not. Be well. Take care.